Right, I think we'll begin now. So welcome everybody to the Landmark Chambers webinar on adult social care. This is the third of four social care webinars that we're running. And today we're covering local authority safeguarding responsibilities and then local authority safeguarding and support for persons from abroad. I'm really sorry we're not going to be able to cover contract because Admas has been unexpectedly detained in court. I'm sorry about that. What we're going to try to do is to get Admas to talk about contracts at the next webinar that we're going to do, which is on the 6th of August. So this one may be slightly shorter, and then that one will hopefully be slightly longer. So again, I'm sorry about that. Really pleased to see so many people joining us today. Obviously, we hope it's going to be useful. So there's just a few housekeeping points. Your microphones are automatically muted, so you don't need to deal with that. And I understand your videos are automatically turned off. So if you have turned them on, can you please turn them off again, because it interferes with something or other on the internet. Very much welcomes questions throughout the session. So what you need to do for that is to use the chat function, which is going to be at the bottom of your screen or possibly at the top of your screen. And if you wouldn't mind, sort of as we go along, that would make it easy for us, using the chat function to ask any questions that you want to ask. We'll sort of deal with as many of them as we can at the end. And if there's anything that we can't address, we'll do our best to follow that up after the event. It's all going to be recorded, apparently, and the slides and the recording is going to be uploaded onto the website. So you can watch it all again if you really want to. If your connection is lost at any time during the webinar, what you can do, I'm told, is just click on the original invite, and then you'll come back in. So Galina is going to be the first speaker. Just to introduce her very briefly, she specialises in public and administrative law, was called to the bar in 2000 and is already a member of the Attorney General's A panel, which is about as high as you can get. Recent cases of hers have covered immigration detention, school exclusions, ATM sites. In the most recent edition of the Legal 500, she is described as a star performer whose written work in particular is of the highest order. Although, having seen her advocacy, I think her advocacy is at least as good as that. She's regularly instructed for and against central and local government, in particular in healthcare, community care, social security, and education. In James and Partners, they said she commanded huge respect for her great experience of representing individuals, schools, and local authorities in special educational needs and disability appeals. And she's a major contributor to two of the landmark books, which I shall shamelessly plug, but just very briefly, the Children's Social Care Law book and the Adult Social Care Law book, which are kind of companion. They do deal with the law, but they're kind of companion volumes to other books already on the market, in the sense that they focus on the kind of case law, and they pot most of that case law. So without further ado, I shall now mute and make myself invisible, and hand you over to Galina.
Just unmute. There we go. and then get the Chamber screen back up. So after that wonderful introduction from Steve, I have revealed myself to be completely technologically incompetent. Does anyone want to tell me how I get the switch to share content? There we are. There we are. As Steve said, I am going to be talking today about local authority safeguarding responsibilities. This is a session now that is purely about safeguarding. So what I'm going to do is set the scene in the sense of running through the general position on safeguarding of adults before Steve addresses the more kind of niche and probably, let's be honest, more interesting, but that will keep you holding on for his talk, question of those duties in particular as they're owed to persons from abroad. So what I'm going to cover, if I can manage to only press the button once, is as set out on the screen there, even in what's probably now 22.5 minutes rather than the 15 that I originally had, it's necessarily going to be something of a whistle-stop tour through local authority safeguarding responsibilities, but it will cover these areas. So firstly, developing local authority safeguarding policies, then inquiries under Section 42 of the 2014 Act, the specific duty of inquiry there. Then I'm going to say something about safeguarding adults boards, which of course are also a statutory duty under that Act, and then touch on the position of persons who lack capacity and local authority safeguarding duties towards them with reference to the Mental Capacity Act 2005. And finally, because this is also a key part of keeping people safe, the role of the Disclosure and Barring Service, the DBS, and specifically when firstly you or local authority need to ask the DBS for an enhanced disclosure certificate, and also when you're under a duty to report matters to them to enable them to consider whether an individual should be placed on the barred list or barred lists. So starting off then with the question of safeguarding policies, of course, under Section 1 of the Care Act, there is a general duty on local authorities to promote an individual's well-being. And well-being is defined as including protection from abuse and neglect. And when carrying out that duty, and indeed all of their functions under the Act, local authorities are required to have regard to, firstly, the importance of beginning with the assumption that the individual is best placed to judge their own well-being, also the individual's views, wishes, feelings and beliefs, the need to protect people from abuse and neglect, but also the need to ensure that any restriction on the individual's rights that's necessary to do that is kept to the minimum that is necessary. Critically, your policy, any policy in this area, needs to be informed by the relevant statutory guidance, which is the Care and Support Statutory Guidance, CAS for short. And I've set out there on the slide paragraph 14.52, which addresses safeguarding policies, adult safeguarding policies and procedures specifically. Obviously, as it says, they need to follow that statutory guidance, and there's a decision-making tree diagram, which we'll come on to. But the purpose of having a safeguarding policy is to make sure that it can be used locally to support reduction or removal of safeguarding risks, as well as to secure any support to protect an adult where necessary to help them recover, develop resilience. And the real focus is to assist those working with adults in how to develop swift and personalised safeguarding responses and how to involve them in decision making. So that in turn should encourage proportionate responses and improve outcomes for the people concerned. And as it says, the procedures may include those that I've listed there. So that's you probably really in a good safeguarding policy want to have most, if not all, of these covered. Statement of purpose, obviously, statement of roles and responsibility, so that people know what it is they're supposed to be doing and indeed what other people are supposed to be doing. A statement of the procedures, and we'll come on to that in a little more detail, for dealing with allegations, including those for dealing with emergencies, so ensuring immediate safety, initially assessing abuse and neglect, deciding whether you need to intervene at all, and of course arrangements for reporting to the police if that needs to be done urgently. a full list of contacts for anyone who might need them, both in office hours and out of office hours, and other relevant national and local voluntary bodies, not just your own contact details. Explanation of how to record allegations of abuse and neglect, and any follow-up inquiries undertaken and any follow-up action that's undertaken. A list of sources of expert advice that practitioners might need to refer to, full description of channels of interagency communication, procedures for information sharing and decision making, a list of any other relevant services that might offer access to support, and the procedure for resolving professional disagreements. So in particular, as to how individuals should be safeguarded or how inquiries should be undertaken. Before we get on to the decision-making, the decision-making tree was referred to in paragraph 14.52, and I thought I'd share it because I do love a diagram on a PowerPoint slide, but I'll be absolutely honest, I'm not sure exactly how useful this one is. It seems to be more of a circle than a tree, one where you could start with the section 42 duty, which, as it says, continues throughout. But if the outcomes are achieved, it says down here, no further section 42 action is required, but you still need to evaluate the need for other actions as necessary. For example, advice. If there isn't any, then I think that no box is an end because the arrow is coming into it that way. But if there is any further action necessary, you carry on around your decision-making tree, or circle line is what it looks like, more than a tree, I would suggest. The part 2 of it, potentially a bit more helpful. You start with your local decision-making process, decide whether any action is required. If not, no actions identified, consider what other action or advice or information might still be needed, but then you close the case. Obviously, if there's any criminal activity, you report it to the police, but otherwise you follow through this middle section, decide what's required, identify further possible actions, agree who's going to do it, plan your next steps, feedback to relevant people if you need to, and then either your outcomes are achieved or they're not, and I think probably should have another little red line feeding you back to the start there. So as I say, a little bit easier to follow, but still perhaps not the most informative. Now, it's important, of course, to understand and to be clear in your policy what it is that you're trying to safeguard people from. What does abuse and neglect mean in this context? And CAS has a helpful list and discussion of some examples at paragraphs 14.16 through to 14.26. Those include, as I've set out there, physical abuse, and that's fairly obvious what it means by that. Assault, hitting, slapping, misuse of medication is one that's listed under physical abuse, and restraint or inappropriate physical sanctions, which may be particularly relevant when we come on to talk about, in particular, people who lack capacity. Then domestic violence, of course, and there's a cross-government definition of that, includes not just physical violence, but psychological, emotional abuse, honour-based violence or abuse, and also financial abuse, which is dealt with separately under further heading as well. Sexual abuse, of course, psychological abuse, financial or material abuse, which includes theft, fraud, might include internet scamming, coercion in relation to an adult's financial affairs or arrangements, including in connection with wills, property, inheritance or financial transactions, and misuse or misappropriation of property, possessions or benefits. Modern slavery is also a form of abuse or neglect that safeguarding policies need to take into account. So human trafficking, which of course is what Steve's going to talk about today to some extent, but that doesn't necessarily have an international element. It's forced labour and domestic servitude that happen, say, in this country with no international element. And traffickers and slave masters use whatever means they have at their disposal to coerce, deceive and force individuals into a life of abuse, servitude and inhumane treatment. So that's something that your safeguarding policy needs to be alert to. The other examples given include discriminatory abuse, whether that's on the grounds of race, gender identity, sexual orientation, disability, obviously likely to be particularly important in this context, but not the only one you need to be aware of, religion or age. And organisational abuse, which includes neglect, poor care practice within an institution or specific care setting, such as a hospital or care home, for example, or in relation to care provided in one's own home. It might be a one-off incident, it might be ongoing ill treatment, and it might be outright neglect, it might simply be poor professional practice as a result of the structure, policies, processes within an organisation. And then finally, should touch on self-neglect. So neglecting to care for one's own personal hygiene, for example, health or surroundings. And the guidance is clear, it includes behaviour such as hoarding. It may not prompt a Section 42 inquiry, which we'll come on and talk about in a moment, but an assessment should be made on a case-by-case basis. And the principles that should inform your safeguarding policy are also set out in CAS at paragraphs 14.13, 14.14. The key principles that underpin all adult safeguarding work are firstly empowerment, which is described as people being supported and encouraged to make their own decisions and to give informed consent. So being asked what they want as the outcomes from the safeguarding process and that information directly informing what happens. Then prevention, so helpfully defined as being better to take action before harm occurs, but what that means in real terms is that the person at risk, potentially at risk, receives clear and simple information about what abuse is, how to recognise the signs of it, and what they can do to seek help. Proportionality, obviously, is key. So it's important that any intervention, any intrusive response to the risk presented is as unintrusive as possible, as minimal as possible, so that people affected are sure that professionals will only work in their interests and will only get involved as much as is needed. You've then got protection, so that's to make sure you ensure support and representation for those in greatest need, so that they are able to take part in the safeguarding process to the extent that they want. Then partnership, which is about all services working together to provide local solutions for communities, so that communities know that staff will treat any personal and sensitive information in confidence, only share what's helpful and necessary. So although they're working in partnership, not just feeling that they can share information that's been given in confidence without thinking about it, so that people can be confident that professionals will work together to get the best result for the individual. And then finally, in terms of the 6 principles, accountability and transparency, so that those affected by services understand the role of everyone who's involved in their life and are clear that those people understand what they're supposed to be doing to help them as well. Finally, you have making safeguarding personal. That's not one of the 6 principles, but it's kind of an overarching consideration. It's important that everyone involved in safeguarding takes a broad community approach to establishing safeguarding arrangements. So all organisations recognise that adult safeguarding arrangements are there to protect individuals, and all those individuals will have different preferences, histories, circumstances, lifestyles. So that may be, you think, a feature of this talk, that there's no particularly prescribed process that has to be followed in each case. Everything will depend on the circumstances of the particular case. So moving on then from policy to the specific statutory duty under Section 42, I've set out that section on the slide, and you'll note firstly at the end it specifically refers to financial abuse, because there has been some discussion in the past about whether that is the form of abuse, but under Section 42 it's very clearly defined as such. That of course doesn't mean that all the other forms of abuse that I touched on a moment ago don't continue to be relevant. They absolutely do. But the other thing to note about the Section 42 duty to inquire is that it's a very low threshold for that duty to arise. So if a person if a local authority has reasonable cause to suspect that an adult in its area, it only has to be fleetingly in its area, just physically present, has needs for care and support, and those don't need to be eligible needs, as that's used in other parts of the Act, just any needs at all for care or support. If that person is experiencing or is at risk of abuse or neglect in any of the categories that we've just looked at, and as a result is unable to protect themselves against that abuse or neglect or the risk of it, then the local authority is under a duty to make inquiries. And those inquiries, of course, have to be made acting under the statutory guidance that we've looked at, and we'll look at a little bit more of it in a moment. So it's not necessary that the person is experiencing abuse and neglect, just that they're at risk of it, and the level of risk isn't defined. So really any level of risk, even a low level, is sufficient to engage the duty to inquire under Section 42. Once that duty is engaged, then you have to engage in evidence gathering. And this, I think, is a much more helpful infogram from the guidance, because it shows that at the centre of all of this has to be discussion with the individual or representative, confirming the cause for concern and agreeing what outcomes are wanted and what action they want to be taken. And then spreading out from there, you may need or decide to undertake any of these other sources of inquiry. So talking to the GP or other health professional, contacting the Office of the Public Guardian or the DWP if there's a benefits issue. You might need to discuss or report to the police, might need to talk to the CQC or other regulator if it's an institutional neglect case. You might need to talk to the commissioning organisation if it's an NHS organisation case. But at the centre, as I say, of all of it is that discussion with the individual concerned or their representative to make sure you have all of the information relevant to what's happening to them. Okay. The nature of the inquiry, there's some guidance on this in paragraphs 14.77 and 14.92 of CAS. It has to be appropriate and proportionate. It might range, as I said, from a conversation with the adult through to a full multi-agency plan. It must, at all stages, record the adult's views, wishes, and any immediate action that's taken and the reasons for that, so it's very clear what's happened. You're not trying to work it out afterwards. And even if an adult with capacity doesn't want action to be taken, the information that's gathered can still be shared in order to assess the risk of harm. Now, my colleague Ben, I think, fortunately, is going to cover data protection next week, so I'm not going to go into that in any detail. But it's important to have arrangements for data sharing that clearly set out the processes and principles that are going to apply in this context so that information can be appropriately shared, because no professional should assume that someone else will pass on the relevant information. It's important that everything that you have is pooled appropriately. Your inquiries need to be obviously in accordance with your policy. They need to be done in a timely fashion. And it's really important to generate clear records of any meetings or decisions, as I've said, and insofar as possible, to involve and empower the individual, which may mean that you need to undertake a mental capacity assessment or the assessment of a need for an independent advocate. I'm going to come on to talk about those in a little more detail in a moment. Proportionality is a key theme here, but it's also really important that third parties, who may of course include potential perpetrators of the abuse or neglect, are treated fairly. So whilst the absolute focus has to be on the individual who's at risk, you mustn't lose sight of having a fair process for everyone else that's involved. And it may be necessary ultimately to provide support and protection in accordance with a safeguarding plan. And so as a result of the inquiry, any action that needs to be taken, the local authority will be the lead agency for that, but partnership working, multi-agency working is vital. If an adult lacks capacity, it might be necessary to take action under the Mental Capacity Act 2005. I'll touch on that in a bit more detail in a moment. And there's also, of course, the inherent jurisdiction of the High Court, which might be invoked where you've got a vulnerable adult who's experiencing duress, for example, but actually has capacity. And then there are still things the High Court can do. You may need to report the perpetrator, I've touched on that already, may need to provide care and support, and CAS is explicit there at paragraph 14.107, where the local authority determines that it should itself take further action, for example, in a protection plan, then it will be under a duty to do so. And that may require an assessment under sections 9 and 10 of the 2014 Act. And important to remember that under section 11, even if an adult refuses an assessment, if that adult is experiencing or at risk of abuse or neglect, so if you're in the territory of safeguarding, then the local authority is still under a duty to assess insofar as it can. And finally, you may feel there may be a need to exercise various powers of access under the Mental Health Act, Mental Capacity Act, Public Health Acts, or to invoke the help of the police or the courts, if none of those are applicable in the particular situation. I said I'd touch on independent advocates. They're provided for by section 67 of the 2014 Act, but section 68 provides that if there's going to be an inquiry under section 42, then a local authority must ensure that an independent advocate is provided if any of the criteria in section 68.3 are met. So if the local authority considers that in the absence of an independent advocate, the individual would experience substantial difficulty in either understanding relevant information, retaining that information, or using and weighing that information as part of the process, or in communicating their views, wishes, or feelings, and whether that's by talking, using sign language, or any other means. So they may need an advocate and an interpreter for sign language, but the role obviously goes much wider than that. And it is, as I say, a duty on the local authority to arrange for that person to be available to represent and support the adult if the conditions in subsection 3 are met. I'm going to go on then to talk about safeguarding adults boards. They're established or required under sections 43 to 45 of the 2014 Act, and the relevant statutory guidance in CAS is at 14.133 to 161. Every local authority has to set up a safeguarding adults board to ensure that local safeguarding arrangements and partners act to help and protect adults, and the definition of the adults who need to be helped and protected by the safeguarding adults boards is the same definition as section 42. So in the area, need for care and support, and experiencing or at risk of abuse or neglect. And the membership of the Safeguarding Adults Board is required to consist of representatives from the local authority, the local CCG, and the police, amongst others, as a minimum. The core duties of the Safeguarding Adults Board are firstly to produce a strategic plan, how it's going to meet its main objectives, what its members will do to achieve that main objective. Then to provide an annual report about what it's done during the year to achieve that objective and to implement its strategic plan. But perhaps most significantly, to carry out safeguarding adult reviews under section 44. And the results of those reviews must be contained in the annual report. Or a safeguarding adults review must be held, section 44 provides, if there's reasonable cause for concern about how the safeguarding adult board or any members of it or any other persons with relevant functions worked together to safeguard an adult. If either the adult has died and the safeguarding adult board knows or suspects that the death resulted from abuse or neglect, or if the adult is still alive, the safeguarding adult board knows or suspects that the adult has experienced serious abuse or neglect. In either of those cases, it's a duty to conduct a review. You may also conduct a review in any other case involving an adult in the board's area with needs for care and support. So that's obviously a very wide power to use where appropriate. Again, there's an obligation to appoint an independent advocate if the Section 68 criteria that we just looked at are met. Where an individual lacks capacity, then of course there's provision made in the Mental Capacity Act 2005 and the accompanying Code of Practice. I've set out the key points here insofar as they're relevant to safeguarding. So firstly, it might be necessary to apply to the Court of Protection, for example, to stop a perpetrator who's living with or contacting an adult who's at risk. You obviously need the authority of the court, so another application to the Court of Protection, if it's necessary to remove a person who lacks capacity from their home or to restrict their contact with others. And it may be that that application needs to be made on an urgent basis, although of course you should always give as much notice as possible to any person affected, as far as that's consistent with the welfare of the adult concerned. Finally, because I'm conscious that I've been talking for some of Steve's time as well, just want to touch on the role of the DBS here. It has a role both in barring, this is disclosure and barring service. The disclosure part is what used to be criminal record, what used to be the CRB criminal records checks. The barring part is operating to lists of persons who are not allowed to work with children and, most relevantly here, vulnerable adults. The Section 35 of the Safeguarding Vulnerable Groups Act places a duty on a regulated activity provider, I've highlighted that term and I'll come back to it, who holds any prescribed information in relation to a person who's engaged in regulated activity provided by him, effectively if that person is sacked or resigns in circumstances where the reason for them ceasing to work for that organisation might engage the DBS's barring powers. Barring powers isn't a statutory term, but the statutory definition was a bit longer and more unwieldy, and I'll explain what those barring powers are. So the DBS scheme effectively, as I said, involves having these two lists. There are some offences which lead to an automatic bar. So if the DBS is informed that a person has committed murder, for example, then they automatically go on the list and they have no ability to make representations or to come off the list. Obviously, if any employee if any local authority employee was convicted of murder, well, they find out anyway, but you have a duty to inform. There are other offences which lead to which mean that the DBS can include the person on the list or will include the person on the list subject to the right to make representations. And if it appears that anyone has committed such an offence, and then again, the DBS should find out through the Police National Computer, but duty on employers to inform them. All you need to know here is that those are contained in the Safeguarding Vulnerable Groups Act 2006, Prescribed Criteria Miscellaneous Provisions Regulations 2009. But you also would have a duty to inform if there's a suspicion of relevant conduct, which also engages the DBS's barring powers, and that's a very wide definition. It includes endangering or conduct that endangers or is likely to endanger a vulnerable adult. It also includes various things such as sexual material relating to children, including possession, sexually explicit images that depict violence against human beings, conduct of a sexual nature involving a vulnerable adult if it appears inappropriate to the DBS, and so therefore, of course, if it appears inappropriate to the employer, and also there's a very wide provision about anything that might risk harm to a child or vulnerable adult. The duty arises in relation to regulated activity providers, because of course it's regulated activity that persons on the list are barred from. And that's defined in Schedule 4 of the Safeguarding Vulnerable Groups Act. In relation to vulnerable adults, it's a healthcare, relevant personal care, which is, there's a list of items there, social work, household assistance if that's needed because of age, illness or disability, assistance in conduct of the adult's own affairs, transporting them, a term that's used as conveying if they need that due to age, illness or disability. So obviously a wide range of things that might be done for vulnerable adults by local authorities. And if anyone involved in those activities leaves that employment for those reasons that might engage the barring powers, then there's a duty to provide that prescribed information to the DBS. That's set out in the Safeguarding Vulnerable Groups Act Prescribed Information Regulations 2006, and essentially it's the reasons why you think the barring powers are engaged, name, date of birth, national insurance number, all kinds of things about the work that they've been doing, their employment documents, etc. But the really important thing is to understand what regulated activity is and what the triggers are for engaging your duty to report as set out in those regulations. Okay. So finally, when do you need to check with the DBS to get a enhanced criminal record certificate? Well, under section 113B of the Police Act 1997, an enhanced criminal record certificate must be issued if a proper application is made on the ground that it's required for the purposes of an exempted question that's asked for a prescribed purpose. The prescribed purposes are set out in the Police Act 1997 criminal records regulations, and they include employing someone to work in regulated activity. So it's circular back to what we've just been looking at. And an exempted question is essentially one that relates to spent convictions, because of course otherwise you'd get them on a disclosure check, or standard disclosure check, where someone's going to be employed again in regulated activity or similar things. So as well as reporting to the DBS, it's obviously very important to make sure that checks are carried out properly to ensure that adults who are looked after in any way by local authorities are properly safeguarded. As I say, something of a whistle-stop tour, but I'll hand over back to Steve now.
Thank you very much. Thanks, Galina. That was really, really interesting. Right, safeguarding and support for persons from abroad. I'm going to be focusing on the support aspect for reasons that will become pretty clear towards the end. Now, there are some people on this planet who really enjoy adult and children's social care, and they do both. And they find it very interesting, very stimulating, but they want more. They want extra complication and complexity and excitement in their lives. And there are also people in this world who really enjoy immigration law, and of course that can be about as complicated an area of law that you can find. But even so, it's not enough for them. They want more. And for people like that, safeguarding and support for persons from abroad is just absolutely perfect, because it contains the best of both those fields, and with plenty of housing law coming in and social security law as well around the edges. So my tactic is just to try and make it as simple as possible. As someone who has sort of spent many years in this field, totally involuntarily, I find each component of it perfectly complicated enough. Thank you very much. It's just the way things happened in my life. So, to share my lack of competence, I can't even get the screen to move. Here we go. So this introduction, 4 issues. So as everyone knows in broad terms, Parliament has legislated to limit local authority duties and powers in relation to asylum seekers and other overseas nationals. And except where it's necessary to draw distinctions, I'm going to refer to such people as persons from abroad, PFAs. And in my opinion, the easiest way of addressing cases like this is to ask 4 questions, to break it down in this way. First, is the person from abroad entitled to, or can they be provided with, is there a power to provide them with a local authority service? Under the terms of the legislation governing that particular service, but also taking into account anything in that legislation that imposes a special hurdle in relation to people from abroad. A classic example being Section 21 of the Care Act 2014, which imposes a harder test for persons from abroad to qualify for eligible care and support services, and I'll say a little bit more about that in due course. So that's the first question. And if the person from abroad doesn't qualify, I mean, if they're not entitled to care and support, if they don't have an eligible need, for example, that's generally the end of the matter as far as the local authority is concerned. But if the person from abroad qualifies, so far, looking at, for example, the Care Act 2014, not necessarily, you might be looking at aftercare services under the Mental Health Act 1983, for example. But if the person from abroad qualifies thus far, the next question is, well, does that service that they qualify for fall within the list of barred services in Para 1 of Schedule 3 to the 2002 Act? And if it does the person from abroad fall within the list of excluded persons in Paras 4 to 7 capital A of Schedule 3? So if the service is barred, and if the person falls within an excluded group, that could be the end of the matter. But one must then ask whether the third question, is it necessary for some provision to be made for that person in order to avoid the breach of a person's rights under EU law or the ECHR? A person will normally be, that person needing the service, but it might necessarily be that person, it could be somebody else. So if it is necessary for some provision to be made in order to avoid the breach of a person's rights under EU law or the ECHR, then the local authority will almost certainly be under a duty to make that level of provision within that type of service available. But if not, it's then necessary to look at the fourth question that you see there on the screen, and that those regulations, one basically hardly ever comes across them. It's a very limited form of temporary accommodation for refugees and EEA nationals with a dependent child who have agreed to leave. So central government support, as you can see, I've sort of set out the outlines for central government support there. But today the focus is going to be on local authority duties and powers. So I'm not going to expand on the detail of central government support. Obviously, its existence is, we're talking about asylum support, obviously under Part 6 of the Immigration Act 1999, or support for failed asylum seekers under Section 4. We deal with that in our books on adult and children's social care law in a little bit more detail. I'm not going to look at it in any detail today, except later on, where I'm going to consider the interface between Home Office support and local authority support. So, local authority support under the Care Act 2014. So actually, I think one or two people have got their videos on inadvertently. If they wouldn't mind switching them off, that would be great, because it's just a little bit distracting. So the starting point for adults in most cases, I'm going to focus on, is to look at the Care Act 2014 and to look at whether they've got an eligible need for care and support under that Act. So that's just applying all that one normally applies under the Care Act 2014 and the eligibility regs. Suppose there is an eligible need, then one turns to Section 21 of the Act which prevents a local authority from providing care and support to an adult who is subject to immigration control, etc., where their needs or future needs have arisen solely because the adult is destitute or because of the physical effects or anticipated physical effects of being destitute as further defined. So section 21 of the Act brings in the definition of persons who are subject to immigration control that you find at section 115 of the Immigration and Asylum Act 1999. So one of the big points here is to recollect that an EEA citizen cannot be a person subject to immigration control at the moment. I'll say a little bit more about EEA citizens later on. The main groups of people who are subject to immigration control are people who need leave to remain and who don't have it, or who do have it, but it's subject to a condition of no recourse to public funds. So that's what you look at to see if the person before you, or who you are representing or assessing or otherwise dealing with, is the person subject to immigration control. To understand whether they are destitute for the purposes of section 21, again, there's a bit of a paper chase. You have to look at the definition of destitution in section 95 of and schedule 8 to the Immigration and Asylum Act 1999, striking out references to the Secretary of State and replacing them with references to the local authority. So again, that paper chase, which is rather convoluted, is all set out in our textbooks, but the critical part of the definition is in section 95, subsection 3 of the 1999 Act, and it says that a person is destitute if he does not have adequate accommodation or any means of obtaining it, whether or not his other essential living needs are met, or he has adequate accommodation or the means of obtaining it, but cannot meet his other essential living needs. In other words, either they are completely homeless, can't get accommodation, or can't meet their sort of, can't provide themselves with food, toiletries, that kind of thing, or both, as is often the case. So, yeah, let's see on here. One, these days, section 21 doesn't come into play that often, although sometimes it does. One does very occasionally come across people whose needs for care and support have actually been caused by illness resulting from destitution. It does happen from time to time. I think one of the main functions of section 21 is to provide part of a sorting mechanism for distinguishing between persons from abroad who might be accommodated and supported by the Secretary of State under the 1999 Act and other destitute persons from abroad with certain levels of care need who might be accommodated and supported by local authorities under the Care Act 2014. So just to sort of expand on this rather brief bullet point note here, the sorting mechanism works in this way. First of all, on the proper construction of the statutory scheme for asylum support and the statutory scheme for care and support, support from the Secretary of State is largely residual, so that where a local authority is under a duty or has a power to provide support to an adult person from abroad, then the Secretary of State may not do so. And the authority for that is the good old case of Westminster versus NAS 2002 UK HL 38. So then that gives rise to the question, well, when may a local authority have a power or be under a duty to provide accommodation plus support to a person from abroad? Well, that arises when the person from abroad satisfies 4 conditions, only 4. So first, they have to be destitute and eligible for care and support under the Care Act 2014, applying the normal test under the eligibility regs. Second, it mustn't be the case that their needs have arisen solely because of destitution. See section 21, which we've already looked at and which is an important part of this sorting hat type mechanism. Third, the person mustn't be excluded by Schedule 3 to the Nationality, Immigration and Asylum Act 2002. And that's often the really critical point, and I'm going to say a little bit more about that. And fourth, they need the sort of care that is normally provided in a home, whether ordinary or specialised, or is the sort of care that would be effectively useless if the applicant didn't have a home. And the authority for that is the SL case in the Supreme Court, which is there in your bullet points. So I'm going to come to Schedule 3 in my next but one train of thought. I'm going to just look in a little bit more detail at that very last issue. Obviously, it's a highly artificial test which the Supreme Court has effectively cobbled together in the course of three hearings, three different cases in the 2000s, to try to make sense out of a lot of very complex machinery and a lot of very complex case law. And I was in all 3 of those Supreme Court cases, and even I struggle. I mean, I really do. And that's where they got to, and that's been the test that has applied since 2013. And common sense and self-preservation may suggest to sort of everybody concerned that we just sort of stick with that and do the best we can with it. And in fact, Lord Carnwath did say in SL that he expected from now on decisions in this particular area to be essentially factual and to be decided on the ground. And he effectively begged lawyers not to really create any more legal difficulties. The facts of SL were that he was mentally unwell. He was very mentally unwell. He required weekly meetings at which he was offered advice and encouragement, general monitoring of his mental health and progress, the arrangement of contact with counselling groups, referral to a befriender service. And Westminster had been very careful to arrange all of the, no criticism there, been very careful to arrange all of these things so they took place outside of his home. And to be fair, they're not the sort of service that is normally provided in the home anyway, although they can be. So he fell foul of the first limb of the test. He didn't need services that are normally provided in a home, ordinary or specialised. And then the Supreme Court then went on to decide in his particular case, these services wouldn't be effectively useless if he didn't have a home. Now, as SL's counsel, I have to say, I was surprised that the Supreme Court felt able to reach that factual conclusion, bearing in mind that they were sitting in an appellate capacity and the conclusion hadn't been reached by anybody before, and given that he actually was pretty seriously mentally unwell. But there you go. I mean, for anyone else apart from me, the decision on a particular fact may not actually matter that much. When you've got somebody who is mentally unwell, the test is there. Will services for them be effectively useless? unless they have accommodation. And I would respectfully suggest that for people with any kind of serious mental illness, mental health services will very often be effectively useless unless they've got somewhere to stay. Now, despite Lord Carnworth's sort of plea, there have been one or two attempts to shake the tree. They haven't really succeeded. SG and Haringey was one pretty firm attempt. And to cut a long story short, the Court of Appeal effectively declared all of the proceedings that were relevant to this particular issue as academic and sort of just binned them off. And that's effectively what's occurred in every other case, of which there have been a few. GS versus Camden, which is 2017, PTSR 140, AR versus Hammersmith and Fulham, 2018, EWH 3453, and a case called Aburris and Southwark, 2019, EWHG 2754. So the tree has never been shaken. It's probably maybe kind of slightly useful to say a little bit about SG. The facts of SG, and in SG, the judge, the first instance, decided that SG was ineligible for local authority support because he didn't satisfy the SL test of needing services that were normally provided within the home, or would be effectively useless unless they were provided to him. So the services that were, sorry, in fact it was a woman, SG, the services that were provided for her were assistance designed to improve her resilience, assistance in learning by rote certain journeys to and from her home, being accompanied to appointments outside the home, being given nutritional and shopping advice, being assisted by a local shopkeeper with using money in the shop, being given counselling, etc., by freedom from torture, and getting assistance with general matters, including arranging various other kinds of appointments. And so the judge decided, probably pretty uncontroversially, that those were all things that weren't ordinarily provided in the home and that wouldn't be effectively useless if she didn't have a home. More controversial, and I think one can look at those and probably treat those as pretty reliable indicators of where a case might fall on the wrong side of a dividing line from an applicant's point of view. More controversially, the judge also agreed with her that she was visited at home and her home environment was checked for her, and that she was also assisted with some domestic and practical tasks in the home by other women who lived there. And what he said about those is he effectively said, well, those are very low down, very low level needs, and I think it's still within the discretion of the local authority to decide that, notwithstanding these services, it's still not appropriate to meet needs through the provision of accommodation. And that was very controversial from the point of view of SG and her lawyers, and it went up to the Court of Appeal, and the Court of Appeal declined to deal with the matter on the basis that it become academic. So that still remains there potentially as an issue of controversy that might be decided in a case where a person has very low or level needs of the kind that will ordinarily be met in accommodation. Can a local authority still say, well, you're a central government case, you're a case for the Home Office? So otherwise, leaving that aside, I just thought the test in SL is not going to be shaken and is going to apply under the 2014 regime, just as it did under the 1948 regime. So just before moving on to another slide, everybody's probably desperate to see another slide, but just to mention, of course, that there are going to be some cases where there is no potential overlap between a local authority and the Secretary of State. There are going to be some cases where the Secretary of State simply doesn't have a power to provide asylum support, and only the local authority can help. So in those cases, it's going to be absolutely critical for the applicant to persuade the court that the most liberal approach to those sort of 4 criteria is appropriate. Otherwise, they just won't get anything at all. And these are people, these would be adults who've got dependent children and who are waiting for a decision on their application for leave to remain under Article 8, because it's under Article 8 rather than Article 3 or under the Refugee Convention. Secretary of State doesn't have any power to provide asylum support, or they will be single adults, you know, without adults, rather, I should say, without dependent children, who again are waiting for decision under Article 8, which again won't allow the Secretary of State to provide asylum support. So those are cases. In other kinds of cases, it matters, but it's not a matter of life and death for the person concerned to get support from local authority. In these last cases, it really matters hugely, and it could potentially be a matter of life or death. I've certainly had clients in that situation in my time who have become extremely unwell. Now, Schedule 3, the statutory bar in Schedule 3, which was the third of those 4 conditions that needs to be satisfied if a local authority is going to be entitled to provide support. Oh, what have I done? Questions. Schedule 3. We don't want any questions. So that's Schedule 3. There, that's an outline of Schedule 3. So this is the, we've looked at Section 21, which is sort of bolted into questions that arise about eligibility under the Care Act 2014. You've then got this sort of extrinsic bar to eligibility under Schedule 3 of the 2002 Act. And it starts off in Para 1 of Schedule 3 by saying that a person to whom this paragraph applies shall not be eligible for support or assistance under, and then there's a whole sort of raft of care and support services, and whenever people like me popped up and found a service that hadn't been included, someone amended the legislation to put it in this list. So it's now pretty comprehensive as far as concerns pretty much any kind of care and support service, with 1 or 2 exceptions I'll come to that one can think of, and it includes now anything under the Localism Act. And it then applies itself to classes of persons which are set out from Paragraph 4 of Schedule 3 onwards. And these people are persons or dependents of persons with refugee status abroad, that's Para 4, EEA nationals and their dependents, that's Para 5, failed asylum seekers lawfully present who fail to cooperate with removal directions, that's Para 6, persons in the UK in breach of the immigration laws unless they're asylum seekers, and failed asylum seekers with dependent children who've been certified by the Secretary of State as failing without reasonable excuse to take reasonable steps to leave the UK. And all of these categories have their own sort of difficulties and complications, which we go through in the book. But the sort of big category that one comes across most of the time is Para 7, the penultimate category. People who are in the UK in breach of the immigration laws, and who are no longer asylum seekers. So these are basically going to be people who claimed asylum after arriving in the UK, which is why they're unlawfully here, and whose asylum claims have then been rejected. So just a few sort of points and qualifications here. The exclusionary effect of Schedule 3 doesn't extend to 3 cases that is useful to draw attention to. First of all, obviously it doesn't apply to British citizens, and it doesn't apply to children. Whatever their immigration status is, it just doesn't matter, so long as they are children under 18. Doesn't apply to Zambrano carers, because at present they are all lawfully present in the UK in the exercise of EU rights. And it doesn't apply where the withholding withdrawal of support, travel assistance, temporary accommodation regulations applies. And hypothetically, there might be other regulations that disapply Schedule 3, but there actually aren't any at the moment. But the big sort of get-out clause for the purposes of Schedule 3 is Para 3 of Schedule 3, because Para 3, as I already explained briefly before, Para 3 of Schedule 3 disapplies the exclusionary effect of Schedule 3 whenever it's necessary, and insofar as it's necessary to do so, to avoid a breach of a person's ECHR or EU rights. So this is often the all-important provision. And the approach of the courts to Para 3 of Schedule 3 has been to treat it as necessary to provide basic support to avoid a breach of ECHR rights in a case where otherwise two conditions are met. First, is the applicant destitute? And if so, if their needs aren't met, will they be pushed away from the UK as a result of not having their basic needs met? And essentially, where a person can show that they are destitute, the courts could willingly accept that unless their needs are met, they will be pushed away from the EU. But that's only the first condition. The second condition is, would having to leave the UK, would being pushed away from the UK as a result of destitution, would that be incompatible with their rights under the ECHR or, for example, under EU law? So when will that be the case in an ECHR context? I'll deal separately with the EU law. That will be the case, according to the courts, where a destitute applicant has got an outstanding application for leave to remain on refugee or ECHR grounds that isn't manifestly hopeless or abusive. And the sort of best case for that is a case called Clue in Birmingham, which is 2010 EWCA Civ 460. So in my experience, if there is an outstanding application for leave to remain on refugee or ECH grounds, a local authority usually just treat the criteria in Para 3 of Schedule 3 as being met if the person is destitute. And that's probably, well, that's undoubtedly a pretty sensible approach, because the threshold is very low. All that the person needs to demonstrate is that their repeat application isn't manifestly hopeless or abusive. But you do get times where an applicant for local authority services has made repeated applications, or for some other reason, because of more than one application and perhaps other factors, local authority alarm bells have set ringing. And in a case like that, a local authority may, and certainly is entitled to, in my view, require the applicant to disclose their immigration papers to them as a condition of receiving support, and then in practice, send them to an experienced immigration lawyer for an advice as to whether or not the repeat application is manifestly hopeless or abusive. The threshold is obviously very high or very low, depending on which way you're looking at it. But experience has shown that from time to time, repeat applications are made that can properly be described as manifestly hopeless and abusive. It does happen. I'm sure we've all seen it, and some of us may have seen it quite often. And in such cases, neither the local authority nor indeed the Secretary of State has any duty to make support available, with the result that we're in this rather grim situation from one point of view of people in the UK who are not eligible for anything whatsoever and simply have to manage as best they can while their application is looked at, their repeat applications looked at by the Secretary of State, which can take some time. As far as concerns EU law, very, very shortly, there isn't a duty under EU law to make social care provision available for EEA nationals and their family members who aren't lawfully resident in the UK under the EU treaties, for example, because they're unemployed persons. There's no duty if they're present simply as visitors or job seekers. But if they are here in a properly qualified role, then there's a duty of equal treatment, and a local authority will have to end up providing them with care services and providing, more to the point, perhaps the old granny, the old family member who's come across to join them with care services on an equal basis to UK nationals. And that remains the case now. After the end of this year, EU citizens will have to show a right to remain on some other basis, which may or may not entitle them to social care. But if it's under the EU settlement scheme, which I think is going to be likely in those cases, then that will effectively preserve their rights. And then just finally, a local authority always can, I hate this as a no-brainer, always can and always must take urgent emergency steps to prevent inhuman and degrading levels of suffering on an interim basis where there's uncertainty as to what the position is, or pending the person concerned leaving the UK if that's what they've agreed to do. That, I hope, is a no-brainer. They can always step in and must always step in those circumstances. Now, I'm going to spare you the questions and just move on to children. I'm going to deal with children a little bit more speedily. So unaccompanied asylum-seeking children will almost certainly qualify for accommodation under Section 20 of the Children Act 1989, which doesn't impose any special restrictive criteria on children from abroad. After they turn 18, they will, in general, continue to qualify for local authority support under the children leaving care machinery up to the age of 21, and potentially longer if they continue to be supported by the local authority to pursue a course of education or training. I'm not going to go into the detail of children leaving care machinery, which is kind of probably a complication too far for a Thursday afternoon. The critical point though, the important point though, is that once a child turns 18, they become an adult, obviously, and then Schedule 3 of the 2002 Act, which does not apply to children, comes to apply to them, and it bears on them when they apply for children leaving care services. And that means that they only remain eligible for children leaving care services so long as they remain destitute and are an applicant for international protection, an asylum seeker or an Article 3 leave seeker, or a failed applicant with further representations which are manifestly hopeless, as discussed before. Only in that latter case will it be necessary to make provision to avoid a breach of their ECHR rights, unless a person is an EU citizen, which is vanishingly unlikely. Children living with their families, asylum seeking or Article 3 leave seeking families, will have their general accommodation support needs met by Secretary of State for the Home Department, or what used to be called NAS accommodation, but the local authority will bring in any specific disability related services that the child needs. So again, I'm going to spare you the questions. Whoops. This is quite finicky. Safeguarding. I'm actually not going to say that much about safeguarding. Essentially, the safeguarding provisions in the Care Act apply to persons from abroad just the same way as they apply to other people. For example, the local authority's duty of inquiry in cases of suspected abuse or neglect in Section 42 that Galina touched on applies to all adults in the area, whether or not they're ordinarily resident, whether or not they're lawfully resident. I mean, potentially a problem arises where a local authority finds it necessary to consider protective action. And in the case of an adult who is subject to risk of abuse or neglect, and if the adult is a person from abroad, then all those restrictions that I've just looked at potentially apply. But I would have thought that even in the case of a person from abroad who's unlawfully present and who can't even surmount the Power 3 of Schedule 3 hurdle, if some support is necessary to avoid abuse, my view is that Article 3 is going to require some kind of provision to be made, at least on an interim basis. I've never come across a case where that hasn't occurred, and I find it extremely difficult to imagine any court tolerating a situation where a local authority was aware of an adult being subject to abuse or neglect, crossing the Article 3 threshold, and not doing anything about it. That's not being tested, but in my view, if it is, there really can only be one answer to that. At least I hope so. That's the end of my talk. So Galina can now make herself visible. It's a bit like Harry Potter, this, isn't it? And we'll see. I've not been able to look at the chat screen while I've been talking, so I'll see if there are. Galina may have done. Oh, there aren't any questions, which is cool. If there are, happy to answer any. I'm hoping Galina hasn't got any questions, because I'm sure there'd be very complicated ones. But if anyone's got a question, would be more than happy to try to answer it. I can't see any. So.
Stephen, I'm not sure if you heard what I said about the chat function.
Oh, no, I didn't know, sorry.
There's one question in it, but it just says Josh exclamation mark.
So yeah, sure no,
not sure that really.
That's not a question.
Any questions from anyone else? I see people are exiting.
Okay, well that's
oh, hold on. I've got one. Can anyone refer a concern to the local authority to trigger the Section 1 duty?
That must mean safeguarding.
Yes.
Yes.
Yes, I think that must be right.
Definitely.
Local authority has to take anything relevant into account.
Absolutely. Absolutely. It doesn't matter where it comes from.
Or they may have to assess the reliability of the source before they start going in and asking other people questions, but yeah, in principle.
Yeah, anyone can refer the concern, but what the local authority then does, I guess, is going to be a matter for the local authority depending on what they think. But if it's a serious concern, I'd like to think that we're going to start to look into it in some way. But I guess, as Galina said, they'll have to make an assessment. Okay, well, thank you so much, everybody. I hope I didn't bore everybody with all that stuff. Thank you so much.
They're all just blinded by the science, Stephen. Giving them too much to think about.
Yeah, thanks everybody for turning up and listening. Hope it was useful. We've got our last one where hopefully we'll have Admats along as well, talking about contracts next week, and hope to see all of you again. Thanks for listening and turning up. Thanks very much.